Good afternoon, and welcome to our webinar today on PFAS, TSCA, and the ticking clock. My name is Jackie Baxley, and I am joined by one of my colleagues today, and we're going to navigate this topic with you guys. Before we get started with introductions and the agenda for our content today, I'd like to just point out some functionality of the webinar platform that we're using today. You will see that there is a Q&A option. Please feel free to enter in any questions as they come to mind. We will take time at the end of the webinar to go over any questions that anybody might have. A common question in webinars is always, will you get a copy of the slides? And yes, we will be sending out a copy of the slides following the presentation today. So you will have the content of this webinar as a reference moving forward. So, with some of those preliminary details out of the way, let's hop right in. So, again, my name is Jackie Baxley. I am the Environmental Health and Safety Practice Leader at HRP Associates. And so, just a little bit about me. I've been in the world of compliance for over 25 years. I'm a professional engineer in several states, and my experience is environmental engineering and risk management consulting, specializing in the areas of environmental health and safety compliance and management systems. As the practice leader here at HRP, my responsibilities include fostering operational performance to a project and management staff of engineers and scientists. And throughout my career, I've had the opportunity to develop a strong working knowledge of the principal federal and state environmental health and safety laws and regulations, the principles of management systems such as ISO 14001, 45001, and the application of sustainable practices and policies. Not only including TSCA that we'll be talking about today, but a whole myriad of those topics. I am pleased to be joined today by my peer and colleague, Sarah Ketteman. Sarah is an environmental attorney at the law offices of Shipman and Goodwin. Sarah is a member of Shipman's Environmental Practice Group, where she assists clients by creating technical and legal solutions to complex regulatory challenges, not unlike some of the challenges we'll be talking about today. Sarah maintains a robust environmental regulatory and transactional practice and guides buyers, sellers, and lenders, investors in industrial and commercial real property transactions to manage risk, including investigation, disclosure, remediation, liability, and other legal and regulatory burdens that environmental contamination can trigger. Sarah has helped clients comply with federal and state environmental health and safety protocols, including regulatory compliance, auditing, and due diligence, and is experienced in the development of environmental compliance programs. She has helped corporate clients navigate enforcement actions brought under TSCA, OSHA, and the Federal Insecticide, Fungicide, and Rodenticide Act. So I am pleased to have Sarah join me today in our presentation for the legal perspective as well as the compliance perspective. So what Sarah and I will be discussing with you today is the TSCA PFAS reporting rule. This is, I think we can still say, relatively new reporting rule. It was passed back in 2023. And I'm going to say I think we can still say it's relatively new because this rule is catching people off guard still today. So we're going to start off by introducing you to the PFAS reporting rule, highlighting the cover activities, highlighting the covered PFAS, and then Sarah and I will talk about navigating the challenges and best practices in complying with this rule. And where we hope you will find this information, the information in this webinar is informative and helps you navigate your potential compliance obligations. Please do make sure that the information here is for general purposes. We only have an hour to talk about a very complex regulatory program. But at the end of this webinar, you will have both mine and Sarah's contact information, and we encourage you to reach out if you have any specific questions or concerns that due to the general informational purposes of this webinar, we're not able to dive into all the individual nuances. All right. So, with all of that, let's go ahead and hop right in to the TSCA reporting and record keeping new rule relative to PFAS. And again, I say new rule, but it was back in 2023 that this was passed. And this rule, which you can find in the Code of Federal Regulations, specifically 40 CFR Part 705, applies to manufacturers. And it's important for us to understand that the definition of manufacturers includes importers. So, just to make sure that there's no misunderstanding, we're going to be saying manufacturers and importers. So, this rule applies to manufacturers and importers that must report on PFAS that is either manufactured or imported from a time period starting in January 1 of 2011 all the way through December 31st of 2022. So there's quite a significant period that a manufacturer or importer needs to look at their manufacturing and importing records to see if they require reporting. And in the report is required for an organization to report known to or reasonably ascertainable information about PFAS manufacturing or PFAS imports. We'll talk a little bit more about what we mean by known to or reasonably ascertainable information. But the timeline of this rule, the reporting window is going to open up in July of this year. That's why we say the ticking clock. July will be here before we know it. Now, this rule has already been pushed back once. So, as I mentioned earlier, it was passed in 2023. The original reporting window was supposed to open up back in November of 2024, but due to some funding restrictions at EPA, the reporting platform was just not ready to go live yet. As such, kind of uh, fall, I guess, of last year, EPA pushed that reporting window from opening up in November to opening up in July of this year. And that also kind of pushes back the due date. And where the due date was originally going to be mid this year, it's now the due date is going to be early of next year. And that might sound like you've got a lot of time, but if reporting is required for your organization, it's quite a lot of information that you're going to need to sift through, that you're going to need to interpret, collect, and then report. So it might seem like you've got miles of time, but what's the saying? The objects in the mirror are closer than they appear, and that can be said for this rule. Now, if somebody meets the definition of a small importer, then they do have a little bit more time. But for the vast majority of the regulated community out there, the due date for this report is going to be January 11th of next year. So let's talk about what specifically what specific activities are covered by this PFAS reporting rule. So as I mentioned earlier, this applies to manufacturers and importers. Technically, the definition of manufacturer includes importers, but we don't want anybody to get confused with the definition. So we are specifically saying manufacturers and importers are covered by this rule. And it includes importers of articles as well. And this is really important. We're going to define article in just a moment. But it's this element that it includes importer of articles that really has this rule applying to a wide swath of the regulated community. Typically, articles are exempt from a lot of the TSCA regulations. So the fact that this rule includes articles really puts additional burden on the regulated community. And there are no exceptions. This again, those of you that have worked in the EH&S world for a while, there's always exceptions, right? But not with this rule. There's limited to almost no exceptions, and most specifically, there are no exceptions based off of the size of the company or the volume or concentration of PFAS that is either manufactured or imported. So remember, just a few moments ago, I was talking about the look back period of this rule is 2011 through 2022. So it doesn't matter if you imported 1 pound of PFAS, doesn't matter if you manufactured 2 pounds of PFAS. There's no volume or concentration threshold here. It's any amount, and it's regardless of the company size. So what is an article? So if I was mentioning that article, the inclusion of articles makes this cumbersome, what do we mean by an article? An article is a manufactured item which is formed to a very specific shape or design during manufacture, has an end use that is dependent in whole or in part on that manufactured shape or design during its end use, and has either no change of chemical composition during its end use or only those changes of composition which have no commercial purposes separate from that of the article, and that result from a chemical reaction that occurs upon end use or other chemical substance, mixture, or articles, except that fluids and particles are not considered articles regardless of the shape or design. So that is the technical definition. Let's bring it down a little bit. And talk about what are examples of articles. So again, manufactured to a particular shape or size, and that shape or size is kind of integral to its function. Articles can include transformers, cigarette lighters, automobiles, desiccant packets, metal or plastic sheets or bar stock or wire, coated fabric, rolled carpet, sheets of plywood, formed plastics, molded plastic, machined metal parts, finished pipes, other shaped or finished construction materials such as sheetrock or plyboard, batteries, and photographic film. These are just a few of the examples of articles. And so as we start to put the pieces together relative to this PFAS reporting rule, remember, it applies to manufacturers or importers, and it's any amount of PFAS that might be in these articles or any amount of PFAS that was manufactured. So if you are in the textile industry, for example, and you are importing fabric and that fabric is coated with a waterproofing material, then you very well could have imported an article that has PFAS. Maybe you're more in the clothing industry, and you're just importing the fabric, and then here you're shaping it and forming it to the actual article of clothing. Well, again, you're importing that fabric, and if that fabric has a wrinkle resistant coating, a waterproof coating, an oil resistant coating, those are all the types of coatings that have a likelihood of containing PFAS. Similarly, if you are importing a coated part or a device that might be coated in like a Teflon-like material, like pots or pans, for example, those are articles. And knowing what they might be coated or treated in is going to be an indication of if maybe PFAS is involved. And so as we start to build the framework here, covered activities, and what we mean by that is what industries are likely to be impacted by this rule. Well, EPA has identified several North American industrial classification systems, NAICS codes, that are likely going to be impacted by this rule. And so these are the industries that we anticipate either manufacture or import PFAS. So construction. Again, there could be construction material that is being imported, and because of the properties of PFAS, that imported construction material, if it contains PFAS and it was imported during that regulatory look back period of 2011 through 2022, then those construction companies are going to have to report. Manufacturing. So those that manufacture PFAS are going to be subject to this rule. The trade, the wholesale trade and retail trade. A lot of retail components very well could have PFAS, whether it's a cosmetic, whether it's cookware, whether it's furniture. So those in wholesale and retail trade, if they are importing products that have PFAS, they need to be mindful of this rule. And then lastly, waste management and remediation services are also potentially subject to this because of the potential byproduct manufacturing of treatment and thus manufacturing PFAS. So, what PFAS is covered by this rule? And whenever we're talking about PFAS, it's always important for us to have a clear definition of PFAS because you look at any regulatory program out there and they're going to have their own definition of PFAS. So we have a patchwork of PFAS regulations across the United States. And with that patchwork of regulation, we've got a patchwork of definitions. So, relative to this rule that we're talking about today, we are using what's called a structural definition of PFAS. And what that means is if the PFAS either in the article or the PFAS that is being constructed or excuse me, manufactured, if the PFAS meets one of the three structures noted there on the screen, and I'm not a chemist, so I'm not even going to begin naming out the structures, but there are three structural components there. If the PFAS fits into one of those structural definitions of PFAS, then it is subject to this rule. Now, EPA has published a quote unquote list, and this list is based off of known PFASs that would meet this structural definition. But it's important to realize that this list might not be comprehensive or complete with all PFAS that meet this definition, the structural definition. So it's important to prioritize the actual structure of the material over the list. But the list is a good tool to use as well. And as I mentioned earlier, yes, we will be providing a copy of these slides for everybody following this. So the hyperlinks that are presented throughout the slide, you will have this presentation in a PDF format where you'll be quickly able to click these hyperlinks. All right, so the reporting process. So if you manufacture or imported during that look back period of 2011 through 2022, and if there was a PFAS that was involved in that manufacture or import, then you're going to need to report. And the reporting platform is EPA's Central Data Exchange. Some of you might already be familiar with the Central Data Exchange. It is where you do some of your hazardous waste reports. It's where you do your annual toxic release inventory report. Some folks call them Form R reports. If you're used to TSCA regulations, it is also where you have done your chemical data reporting that's due every 4 years. So the CDX is a common tool that is used in EPA, and some of you might have experience with it. But because of the inclusion of articles here, because of the inclusion of things like retail trade and wholesale trade, and because of the no exemptions, we're going to have some folks that are going to be working within the Central Data Exchange for probably the first time. So if you think you're going to have to report, it's important to go ahead and register with the CDX because the Central Data Exchange is a process of registration, setting up account. So registration within CDX is going to be required. So that's a head start you can go ahead and work on so that you can then access the reporting tool that is going to be used by EPA for this report. Now, Sarah and I have we've been in correspondence over several months now about this rule, but here most recently we have been looking for EPA announcing the availability of the reporting tool on CDX for this. We have not seen it yet. If somebody out there has eyes that are more eagle eyes than ours, and you've seen where the reporting tool has been released, feel free to put that in the questions or reach out to us afterwards. But we're looking every week to see when this reporting tool is available. So far, it's not available, but at the current timeline that is set forth in the regulation, it is going to be available before July the 11th, because that's when the reporting window opens up. And then failure to timely file a report will be a violation under TSCA. This is not a voluntary rule. This is a regulatory obligation. So identifying if you're subject, getting that known or reasonable ascertainable information, doing your evaluation, reporting if reporting is necessary, is a compliance obligation. Now, so the reporting tool will be within the Central Data Exchange, and there are different report forms, if you will, that you might need to submit. There is, and what this flowchart is representing is that there are going to be streamlined forms for those of you out there that are only subject to this rule because of the importing of articles. If the only reason why you're subject to this rule is the importing of articles, it's going to be a streamlined form. It's going still going to be a robust data collection and review, but it's not going to be as involved as if you were doing a full review. Similarly, as I was saying earlier, no exemptions. Normally, we would see exemptions for research and development. There's no exemptions for research and development in this rule. So those of you out there that might be a manufacturer, including import solely for R&D purposes and specifically totaling less than 10 kilograms per year, then there will be a streamlined form. Otherwise, you're using the full form. And lastly, maintaining records. So records associated with this regulatory obligation must be maintained for 5 years. So your due diligence, your collected information, all the information you consulted in actually completing the forms and the reports, all of that needs to be maintained for 5 years. And that is 5 years from the date that the report is going to be due on January of 2026. Now, we recommend, and we highly recommend, and we can't stress enough how highly we recommend that you maintain not only records that support that you needed a report and all the information that supports what you did report, but if you, through your due diligence, if you determine reporting is not required, you want to maintain all the detailed information that was assessed, all the interviews, all the interactions that led you to that conclusion that reporting is not required. So if you're in one of those subject NAICS codes and EPA comes knocking on your door and says, how come you didn't report? You're going to have that information at your fingertips that shows your due diligence and shows that you assessed reporting applicability and that you did not have to report because of X, Y, and Z. All right, so with that kind of basic intro of the rule, let's talk about the challenges and best practices. And so I'm going to lead us off with some of the challenges, and Sarah will pop in here and talk about some ways to overcome these challenges and the best practices. So I think it goes without saying one of the biggest challenges of this rule is that look back period. So as I mentioned earlier, the look back period for this rule is 2011 through 2022. I mean, what were we doing back in 2011 through 2022, right? Like that's a long look back period. So what changes occurred in your organization? What people have come and gone that have knowledge in your organization? How has your organization changed through mergers or divestitures during that time period? So that look back period is one of the formidable challenges of complying with this rule. Also, the fact that the rule has limited to no exceptions and incorporates articles, those two together really add a complex challenge, especially because we see a lot of folks that don't normally have to worry about TSCA because of some of the exceptions that are available for TSCA. But with this rule, people that have never really had to worry about their compliance obligations under TSCA now all of a sudden do. And TSCA is a complex regulation. So the challenges of just the no exceptions and the incorporation of articles is going to be burdensome for the regulated community. And then lastly, just gathering that reliable information. So as I mentioned earlier, the reporting standard for this rule is what's called known to or reasonably ascertainable by, which means all the information in a person's possession or control, plus all information that a reasonable person similarly situated might be expected to possess, control, or know. So, this reporting standard requires reporting entities to evaluate their current level of knowledge of their manufactured products, including imports, as well as evaluate whether there is additional information that a reasonable person would be expected to know, possess, or control. And so what do we mean by reasonable here? If you're required to keep records for some regulatory purpose, that would be reasonable to expect that you would have those records. This standard would require that submitters conduct a reasonable inquiry within the full scope of their organization, not just the information known to the managerial or supervisorial employees, not just the information known by the EH&S professionals, but an inquiry within the full scope of the organization. The standard may also entail inquiries outside of your organization, such as your supply chain, to fill some of the gaps of your own knowledge. So this standard carries with it an exercise of due diligence, and the information gathering activities may be necessary for manufacturers to achieve this is really going to vary widely on a case by case basis, based off of kind of each organization and how they're structured. So files maintained by any company employee, such as marketing studies, research and development, sales reports, or customer surveys, may be considered this known to or reasonably ascertainable by information, as well as information from your supply chain. And then information contained in standard references showing use information or concentrations of chemical substances and mixtures, such as maybe a safety data sheet or a technical data sheet or some type of supplier notification. Now, the reason why I have an asterisk next to SDS here, safety data sheets, is use caution with safety data sheets. Safety data sheet is just that it is a safety data sheet that is regulated by OSHA. PFAS is still not regulated by OSHA. If you look up PFAS under OSHA, you're going to see personal fall arrest systems, not this chemical of concern. So we see today, still today, data gaps relative to PFAS on a safety data sheet. So a safety data sheet might be one of the known to or reasonably ascertainable data points you have, but please don't put all of your eggs in the safety data sheet basket, because we see these as significant data gaps relative to PFAS and SDS. And then you're going to document the knowledge gained through discussions, conferences, and technical publications. Essentially, show your math. What did you review? Who did you talk to? How did you come to your conclusions? We'll later discuss recommendations, one of which that we're going to recommend that each organization form a cross-functional team. It is because of this reporting standard of known to or reasonably ascertainable by that having a comprehensive team at the table is going to be so important. Now, it is important to note that this standard does not require that you test for PFAS. So there's no testing burden here. It's just this known to or reasonably ascertainable information. And with those challenges in mind, so now that I've introduced you to the regs, we've highlighted some of the challenges. At this time, I'd like to hand it over to Sarah, that's going to help us navigate some of these challenges and best practices. Sarah?
Great. Thank you so much, Jackie, for detailing this complex rule and some of its associated challenges. Yeah, I'm going to walk you through some of the more practical steps that companies should consider taking to get across the PFAS, the TSCA PFAS reporting finish line. So starting with a consideration for engaging counsel. Now, given the complexities of this reporting obligation, um, companies should really coordinate teams to conduct their due diligence. And I'm just going to provide a few reasons over this in the next slide for why teams are recommended. First of all, thinking about regulatory compliance and interpretation, as Jackie has done a great job explaining, this is a highly technical reporting rule. These are complex regulations. As she mentioned, the chemical definition of PFAS is is different in this reporting rule than other regulations. So this is other regulatory definitions called PFAS, a class of fluorinated organic chemicals that contain at least one fluorinated carbon atom. But this is a structural definition. This is a new definition, then it's definitely going to require technical evaluation. Um, At the same time, lawyers are not going to provide that technical evaluation for what chemicals, what might be imported or manufactured and whether they would fit into this PFAS definition. Lawyers instead would interpret legal requirements, exemptions if possible. Now, Jackie mentioned that there are no exemptions, but whether or not products that are imported or PFAS that are manufactured here might be covered under a different regulatory regime under, for example, the Food and Drug Administration. That could be something that needs to be considered depending on what kind of manufacturing and importing a company would do. So lawyers are available to interpret those legal requirements, those exemptions, and any kind of nuances that could be available to really ensure that your company accurately identifies reportable PFAS and can avoid penalties. Next slide, Jackie. Great. So coordinating a team, you see that there are technical and legal uncertainties, and to really put together innovative solutions that work for companies would require expertise from both technicians and lawyers. It's important to put together one coordinated message, whether it's reporting to EPA or documents, record keeping internally. And that's what lawyers and consultants can help you with. This will help you provide perspective, context, and certainty where possible. Now, there are a number of areas where technical environmental health and safety consultants like Jackie at HRP can really assist. And then at the same time, lawyers can coordinate with your technical team. So while the technical team can assist with the supply chain complexity, where consultants can really assist in navigating complex supply chains to identify PFAS presence in raw materials or products or byproducts. There's also requirements to maintain data accuracy. So there's a proper documentation and record keeping that Jackie foreshadowed in terms of documenting what due diligence has been conducted and why, if there are decisions made not to report on certain PFAS, why those decisions, what's the argument supporting that? And that's a legal nuance that a legal team would assist with. There's also risk mitigation. So the legal liability that I'll speak more to in the next few slides comes in where misreporting or failing to report can lead to EPA enforcement actions, fines, reputational damage. I'm going to highlight some of the risks that you'll see in terms of legal liability in the next few slides. At the same time, engaging counsel early alongside your consultants can help maintain attorney-client privilege, and this will help protect sensitive internal communications during regulatory reviews and during this PFAS due diligence process. Next slide, please. So I mentioned sensitive internal communications, but there's also confidential business information that is part of the reporting platform. So EPA, if you're familiar with reporting under TSCA, there are certain confidential business information protections that companies can apply for. This is CBI. You can, with this rule specifically, claim CBI protection for chemical identity if the chemical is not already on the TSCA inventory. Also for production volume, use information, customer and supplier data, and certain other business sensitive details. This is a time-limited protection, so CBI claims are generally valid for 10 years, after which a company would need to resubstantiate this claim. Otherwise, information could risk becoming made public. CBI also allows companies to protect and maintain confidentiality in the face of public transparency and public right to know concerns about PFAS exposure. And that is a protection against industry protection of trade secrets. At the same time, the last bullet in this slide, the health and safety studies that might be required to be submitted as part of your PFAS reporting under this rule are not necessarily able to be claimed as CBI. Next slide. So moving away from CBI and what you'd be submitting to EPA and what could be protected, I'm going to go through an overview, exhaustive list of potential liabilities that companies can face. So starting with penalties, under TSCA Section 16, EPA can impose civil penalties for noncompliance. This could include failure to report or late reporting or submitting inaccurate data. There's also knowingly submitting false submissions, and this could trigger criminal penalties, including fines and even imprisonment. Really, what EPA would be focused on here is fines, which are incurred daily, up to $50,000, about $50,000 adjusted for inflation. And this is a knowing or willful action, so it's definitely a higher threshold for EPA to satisfy. Then moving on, EPA enforcement actions. EPA can issue notices of noncompliance or administrative orders, or even pursue legal action to enforce compliance. Now, given the scope of this reporting rule and just how many manufacturers and importers are subject to it, the likelihood of these types of enforcement actions, it's not high, but it is a potential liability that companies should consider. The injunctions and remedial actions, courts could order corrective actions, including requiring additional reporting or even imposing operational restrictions. And then finally, the CBI protections that I gave you a brief overview on the last slide. If CBI claims are improperly justified or deemed insufficient, EPA could deny them, and that would potentially expose a company's trade secrets and proprietary data to be made available to the public. Then to litigation risks. So there are citizen lawsuits. TSCA allows for citizen lawsuits. That means that NGOs, non-government organizations, environmental groups, competitors could sue companies for non-compliance or for failure to disclose PFAS data. There's also toxic tort and liability claims. If reported data show that PFAS are present, companies could face product liability, environmental damage, personal injury lawsuits. So there are definitely significant litigation risks here. There's reputational damage and business risks. So with regards to public negative publicity, public disclosure of PFAS use or data about what is in your products could lead to reputational harm. And there's a concern that it could affect investor confidence, customer trust, brand value. Then there's regulatory scrutiny. Noncompliance could trigger EPA audits, site inspections, or expanded PFAS investigations. Then perhaps most likely, inconsistencies in reporting can pose a liability risk. So if your TSCA PFAS report conflicts with prior submissions, like TRI reporting or even pre-manufacturer notice filings or state disclosures, there's a number of liability risks that could arise. Again, those EPA heightened scrutiny and enforcement actions. So EPA actively cross-checks PFAS reporting data against past regulatory filings. Discrepancies could trigger EPA audits, data requests, investigations to determine whether false or misleading information was submitted. The agency could also require revisions, additional documentation, or explanations for inconsistencies. And finally, companies are likely well aware of the conflicts between state and federal regulatory requirements. So some states, like California, Maine, New York, require separate PFAS disclosures. Conflicting state and federal filings could result in additional regulatory scrutiny. Also, discrepancies could lead to state level enforcement actions, including fines or revocation of business permits or a license. And with that, let's go into some examples, Jackie.
Thank you, Sarah. And one thing I was just noticing as you were speaking, Sarah, is that we just dove right into this TSCA PFAS rule. And there very well could be some in our audience that are not as familiar with TSCA. So just before we dive into this example, I wanted to just kind of highlight one of the reasons why there's all that risk and liability that Sarah was mentioning is in one of the reasons, or the reason why we have this rule, is because PFAS are highly hazardous materials. They are what's called forever chemicals. They do not break down in the environment. They pose extreme health risk to human health and the environment. And so the reason why we see so much activity and scrutiny and risk and liability and this patchwork of regulations around PFAS is because of those persistent and hazardous properties about
Right,
PFAS.
right, Jackie. Right, we're operating with the assumption that audience members are familiar with PFAS. I mean, probably, hopefully not as familiar as Jackie and I are. But if you do need, if you have questions about what PFAS are and more about what the risks are that they pose to human health and the environment, at the end of our presentation, Jackie and I have a few resources and also our contact information. We have a number of articles on each of our respective company websites that you can look to for additional information.
Great. All right. And then you know what? I noticed we've got some questions that are coming in, and I think these examples are tailored pretty well to the questions that have already come in so far. But let's go through some of these examples. So, for example, one, let's say that during the reporting period of this rule, which is 2011 through 2022, your company imported a fabric coated with a waterproofing material. During your due diligence under this reporting rule, you contact the supplier and ask them for the name of that waterproofing chemical that is used on the fabric. In reviewing the available information on that waterproofing chemical, you identify that it contains 5% of PFAS A. And PFAS A, when you look into it, actually happens to meet that structural definition of TSCA. So in this example, this organization is going to be reporting under this TSCA PFAS rule. Why? Because they imported a material during that regulatory lookback period that did contain a PFAS per the definition. Now, let's tie in Sarah's perspective here. What if previously you informed your customers that you had no knowledge of PFAS in your supply chain, but now, as a result of your due diligence for this rule, you now have knowledge of PFAS in your supply chain? Sarah, what would you recommend here?
Sure. From an attorney's perspective, first of all, companies can become, um, you should be aware of FOIA requests, so Freedom of Information Act requests. And this is something that your customers who had previously been told that you had no knowledge of PFAS could do. They could submit a FOIA request to understand and to get EPA, what was reported to EPA under this rule. Really, the liabilities that your company would face depend on the nature of the prior statements, applicable contracts, the scope of regulatory and consumer protection. So first, there's the regulatory liability that I discussed previously. You could also have contractual liability, so claims for damages if a product is recalled or if you have reputational harm. There could be termination of agreements and costs associated with that termination. Product liability and consumer protection, those are more um, consumer lawsuits that could be a risk. There's, for example, we're already seeing plaintiff claims of misrepresentation and fraud and consumer lawsuits. And then, of course, there's reputational damage of, stating one thing and then stating the other. And it's tricky because this TSCA PFAS reporting rule applies to, as Jackie pointed out, PFAS, it's a broad definition, so structural definition, but it is not limited to PFAS that were intentionally added. And so a lot of regulations up until this rule have focused almost entirely on intentionally added PFAS. And this rule really doesn't care. You need to consider PFAS that could be in byproducts, that could be unintentionally added to your products. And so what could companies really consider doing? You could consider putting together a corrective disclosure with accurate information. You could implement enhanced due diligence procedures to prevent recurrence. And then finally, we recommend engaging legal counsel. This will help you address exposure and really develop a narrative around any new findings.
Great. Thank you, Sarah. So let's go on to example 2. So this one's similar but tweaked slightly. And actually, there was a question in the chat that I think speaks to this one. So, what if we manufacture products using articles with PFAS from domestic sources? So, this one's kind of tailored a little bit to that question. So, let's say you purchase coating from a domestic supplier. In your due diligence, you identify that that coating contains PFAS, and that meets TSCA's definition of PFAS. So you apply that domestically acquired coating to your fabric that you manufacture on site. In this example, reporting is not required under TSCA because this rule does not apply to what's called use or processing PFAS, only manufacturing. And a little bit later, we're going to have some links for additional information. And in this additional information, we're going to provide you links to something that's really handy in some of the supplemental information that we're making available to you are these definitions. There is a technical definition for manufacturing. There's a technical definition for processing. There's a technical definition for use. And so if you are acquiring PFAS domestically and processing it through your operations, that is not considered manufacturing. That is considered processing. So definitions are important. And in this particular example, reporting is again not required because you're processing PFAS. You're not manufacturing PFAS. And that PFAS was acquired domestically. You're not importing it. So it does not apply. But again, now you have knowledge in your supply chain. So Sarah, anything you want to
Right.
add to that knowledge?
Yeah, absolutely. So, like you said, this is not reportable under the TSCA rule, but do you want this information protected? And how? You'd certainly want it protected. And what we would suggest doing, just as a starting point, you want to obtain as much information as possible from your suppliers. You can conduct a survey of where the products are going and what requirements exist there for PFAS reporting or phase outs. So just gather as much information and be ready to report where necessary outside of this TSCA rule. For example, some states, as I mentioned, have stricter requirements than the federal government. Canada does too. And the French Parliament approved, I think this week or last week, a landmark ban on using PFAS chemicals in common products, including cosmetics or ski wax, clothing, so forth. The French bill, it still has to be signed by President Macron, but it bans the manufacturing, import, and sale of PFAS in covered products by January. That's going to extend to textiles by 2030. And then there's certain exemptions. But really, what this is saying is this is a broad scope across the globe of PFAS phase outs, PFAS bans. And so even if you don't have this information that's required to be reported for TSCA, keep it handy, keep it in a desk, and be ready to use it for other applicable jurisdictions.
Great. Thank you, Sarah. And this is also a well-planned example as we receive several questions in our chat. What if our organization changed hands in 2019? Do we still have to go back to 2011? What would you recommend for companies going through mergers and acquisitions? Whose responsibility is it to report? So I think this is a well-placed example. So in 2012, Company Big purchased Company Small. In 2019, Company Big divested Company Small, as well as 5 other locations in its portfolio. In 2023, Company Big acquired Company Medium. So Sarah, what is the scope of the due diligence for this? How do we look at these complexities of mergers and acquisitions?
Right. So let's start with that scope question, Jackie. The scope of the due diligence remains the same. This is the submitter. We're talking about who is going to submit this information, and it has to be information that is known or reasonably ascertainable to the submitter. And frustrating, we don't have, necessarily the easiest answer here, but EPA has guidance that it recommends be used for these types of corporate restructures. It's going to require a deep dive review to determine really who is contractually in the position to report, if anyone, and who owns the company at the time the reporting window opens, and really who has the information that is needed.
Exactly, and that is why we invited Sarah to co-present her experience with mergers and acquisitions and due diligence. A legal expert in those matters. Whether you have somebody internally in your team that assists with legal matters with mergers or acquisitions, or you have outside counsel. Really just kind of following those contractual obligations is what's important. And I just want to kind of reiterate something that Sarah said. Who has ownership at the time that the reporting platform opens up?
Right.
So at this moment in time, the reporting platform is scheduled to open up on July the 11th of this year. So if you do not own the company as of July 11th of this year, then unless there's something contractually obligating you to, then you don't have to worry about those activities. Now, kind of a variation of this, and I just wanted to highlight it because I had a conversation with a client along these lines here recently, is even if the site is now closed, if the site was active during the reporting period and the owner of that site still exists, then the owner of that now closed site, so example, you're Company X, you've always been Company X closed this one site back in 2020, let's say. So if you still have known or reasonable ascertainable information from your activities that occurred until 2020, and you still exist as a company, it's just that location no longer exists, you still have the obligation to go through your due diligence. All right. So let's wrap up with just some other recommendations and resources. And even if we go a little over time, we'll be happy to answer any additional questions that come through. So, we've already kind of highlighted the need for assembling a cross-functional team. So just to put a finer point to it, assemble a team comprised of in-house personnel, legal counsel, and environmental experts with TSCA expertise. Engage that outside environmental consultant or counsel to maximize and counsel to maximize the attorney-client privilege benefits when needed and when possible. Sarah outlined a lot of those risks, a lot of those potential liabilities because of just the inherent nature of PFAS. So if you have those risks and liabilities, then we do highly recommend that counsel is involved in that cross-functional team to give you those protections. And then just develop a strategic approach to collect and report only relevant information required for compliance to minimize the potential regulatory or third-party adverse actions and liabilities. So maybe some type of standard operating procedure of how we're collecting data, how we're documenting data, how we're storing data, and so on. But again, that cross-functional team, this cannot be a project that just the person sitting in the EH&S office does. This has to engage all resources at an organization that might have info. Sarah?
Right. Yeah, thanks, Jackie. And turning back to why attorney-client privilege can really provide a benefit to companies, it's really crucial for this due diligence under the TSCA PFAS reporting rule to try to ensure that sensitive communications about regulatory compliance and liability assessments strategic planning, remain confidential and protected from disclosure unless and until ready. Really, the last thing companies want is to have a text message or a Facebook post or an email to be an exhibit in a lawsuit, projected on a screen in a courtroom. And so maintaining attorney-client privilege throughout this process, from the moment that a company gets started in this due diligence exercise, is critical. We can help you understand the limits of what that privilege can be. And again, to stress, you want to really be aware of written communications. If you have a text message coming in within your team of, oh my gosh, this PFAS it's everywhere in this particular product, that can turn into a discoverable material and used as an exhibit. And I already went through the Freedom of Information Act and the risks of having plaintiff happy companies or people FOIAing data requests and data information under this rule.
And so, exercise and document our due diligence to obtaining this reasonable, ascertainable information is important with all of the considerations that Sarah just said about making sure that we're prudent in how we're documenting and communicating. For any manufacturer, particularly those that are considered article importers, who does not know or cannot reasonably ascertain that they manufactured or imported a PFAS, then document it. It's hard to document the negative, but that's exactly what you're doing. You're saying, I talked to these people within our organization. I talked to these departments. You talked to everybody that you thought would have information. You talked to your supply chain. Document your due diligence efforts and that it didn't yield any knowledge about PFAS. And then you have that negative assertion that's documented. It shows your due diligence, it shows your efforts, and so it will hold up to a degree of scrutiny in the future. Um, PFAS is an emerging contaminant, and what that means is our knowledge is going to emerge. And so, at any moment in time, you might not have knowledge, but in the future, you might. So, just documenting the knowledge you reference at any moment in time is important, and retain records that document any information that is reported to EPA. Remember that time frame is 5 years record retention. And ensure information is current and relevant. Already mentioned earlier, just be cautious of safety data sheets, and be cautious of older information. If you've used the same product for 50 years, don't look at a safety data sheet from 20 years ago. Look at a safety data sheet of that product today. If it's the same product, that safety data sheet, the information that safety data sheet is going to evolve over time. You don't want to rely on old data or technical data sheet or spec sheet or whatever records that you're reviewing. Just remember, safety data sheets are not required to have information about PFAS. PFAS is not regulated under OSHA at this time. So just be cautious with it. It can be part of the information, but don't only rely on safety data sheets.